Mr. President, I ask consent the quorum call be suspended.
Without objection.
Mr. President, I've come to the floor again today to speak about an obscure section of immigration law which has a direct impact on the lives of literally millions of people living and working in the United States. I'm here to speak about the plight of immigrant workers who are suffering because of a serious problem in our immigration system known as the green card backlog. Many of these immigrants are essential workers helping to lead the fight against COVID-19. We've just heard tributes on the floor from senators on the other side to these healthcare heroes. But this green card backlog, which I speak to, puts them and their families at risk of losing their immigration status and being deported from the United States. Under current law, there are not nearly enough immigrant visas, also known as green cards, available each year. As a result, many immigrants are stuck in crippling backlogs for years, waiting and praying for the moment when their number comes up. Close to 5 million future Americans are in line waiting for these green cards, including 1 million immigrant workers and their families. Despite this number, 5 million, there are only 226,000 family green cards and 140,000 employment green cards available each year. These backlogs are really hard on families. They're caught in immigration limbo. And what happens to the children is particularly awful. Children in many of these families age out while the parents are waiting for their green cards. What does that mean? They reach the age of 21, and then these children, as adults, face deportation because they're no longer under the age of 21 by the time the green cards are available. The solution to the green card backlog is so clear: increase the number of green cards. I've introduced legislation known as the Relief Act with Senator Pat Leahy and Senator Mazie Hirono. The Relief Act would increase the number of green cards to clear the backlogs for all immigrants waiting in line for green cards within 5 years. And the Relief Act would protect aging out children who qualify for a green card based on the parents' immigration petition. This Relief Act is not new. It's based on the Bipartisan 2013 Comprehensive Immigration Reform Bill. I know a little bit about it. That bill was written by 8 senators, and I was one of them. 4 Democrats, 4 Republicans. We worked for months. We took the bill through the Senate Judiciary Committee. We faced 200 amendments, I believe, and then brought it to the floor subject to even more amendments. And at the end of the day, that bill passed with a strong bipartisan vote of 68 to 32 on the floor of the Senate. But Republicans who control the House of Representatives refused to even consider this comprehensive immigration bill. If they had, we wouldn't be here today. That bill and the provisions we added to it eliminated the green card backlog. Unfortunately, some of my colleagues on the Republican side are still unwilling to increase the number of immigrant visas even by 1. They want to keep these immigrant workers on temporary visas where they are at the risk of losing their immigration status and being deported. Senior Senator from Utah, Senator Lee, introduced a bill, S-386, known as the Fairness for High-Skilled Immigrants Act, to address the green card backlog. I have a basic concern with Senator Lee's bill. S-386 includes no additional green cards. Without additional green cards, S-386 will not reduce the green card backlog. Don't take it from me. Listen to the Nonpartisan Congressional Research Service. Here's what they say about Senator Lee's legislation, and I quote, S-386 would not reduce future backlogs compared to current law, end of quote. This is not a partisan group. It is the Nonpartisan Congressional Research Service. S-386 would not reduce future backlogs. Despite my concern about Senator Lee's bill, I told him I was willing to sit down and work in good faith to see if there was something we could agree on. Last December, we reached an agreement, a good one. Republicans object to increasing the number of green cards, and as a result, even our agreement, the amendment we agreed to, wouldn't reduce the green card backlog, but it was a good bill that we proposed. Let me highlight two key provisions of this agreement. We protect immigrants and their families stuck in the backlog. Immigrant workers and their immediate family members would be allowed to early file for their green cards. This was a proposal from Senator Lee that I thought was good and willing to support. That doesn't mean they receive their green cards early, but they would be able to switch jobs and travel without losing their immigration status. That to me was only sensible. Early filing adds a critical protection that was not in Senator Lee's original bill. It prevents the children of immigrant workers from aging out of green card eligibility, so they will not face deportation while they're waiting for a green card. Our agreement also would crack down on the abuse of H-1B temporary work visas. The amendment we agreed to would prohibit a company from hiring additional H-1B workers if the company's workforce was more than 50 employees and more than 50% of them were temporary workers. These shell companies are created for outsourcing American jobs and abusing the H-1B visa process. I know because Senator Grassley, Republican of Iowa, and I introduced this reform years and years ago when this abuse became so obvious. It targets the top recipients of H-1B visas, which are these outsourcing companies that use loopholes in the law to exploit immigrant workers and to offshore American workers' jobs. 2 weeks ago, I came to the floor of the Senate to ask that we pass this agreement. Unfortunately, at that moment, Senator Lee objected. Instead, he offered a revised version of our December agreement, including changes which are required by the Trump administration. First, Senator Lee wants to remove a provision known as the Hold Harmless Clause. That assured immigrants who were already waiting for a green card, sometimes for years, that they would not lose their place in line because Congress changed the rules in the middle of the game. Second, Senator Lee wanted to delay for 3 years the effective date of this 50-50 rule to crack down on outsourcing companies. I don't believe we should give these companies that are outsourcing American jobs and exploiting immigrant workers a free pass for 3 years. Third, Senator Lee wanted to delay for years early filing for people who are stuck in the green card backlog. Any children who would age out in the meantime would lose their chance for a green card and be subject to deportation. Those changes suggested by the senator from Utah were unacceptable. But because there are so many lives at stake here, families at stake here, and I know the intensity of emotion behind this issue, I was determined to keep working to see if we could find some common ground. Last Tuesday, I sent Senator Lee another compromise offer. The Senate Republican leader is planning to recess the Senate within a few days. So I felt it was important to come to the floor today to try to pass this proposal before the Senate leaves. Let me be clear, this isn't how we are supposed to make laws in the United States Senate. Last year, I sent a letter joined by every Democrat on the Senate Judiciary Committee to the senior senator from Texas, John Cornyn, chair of the Immigration Subcommittee. We asked for the regular order of business in the Senate, which so seldom occurs now. We asked Senator Cornyn, as chair of the Immigration Subcommittee, to hold a hearing on this complicated legislation that addresses the green card backlog. We wanted them to include in the hearing consideration of Senator Lee's bill and my legislation, the Relief Act, a hearing with witnesses, a markup, a bill, a vote in the committee, a vote on the floor. It's almost like something called the United States Senate used to be. This would help the Senate to understand during the course of this hearing and debate the impact of each of these proposals and to pass legislation that would actually fix the backlog. That really is how the Senate used to work. I know it's hard for newer members to believe it. The Immigration Subcommittee is certainly not too busy to take up this hearing. For this session of Congress, which began a year and a half ago, the Immigration Subcommittee of the Senate Judiciary Committee has held one hearing. One. Unfortunately, Senator Cornyn rejected our request. This leaves me no other option but to bring this proposal directly to the Senate floor. So let me explain what my amendment would do. First, it would ensure that children of immigrant workers do not age out while waiting for a green card. This provision would not increase the number of green cards. It would not provide any special benefits. It would simply allow children of immigrant workers to keep their place in line for a green card and to be protected from deportation until they can get their green card. Second, my amendment would delay the bill's section that changes the distribution of green cards by 1 year. This provision, which Senator Lee actually proposed earlier this year, would not replace the hold harmless provision. However, it would allow processing time for immigrants with pending applications to get their green cards. Third, my amendment would allow for immediate implementation of the 50-50 H-1B visa rule. I've been told that the purpose of delaying it for 3 years was to protect those currently working for these companies. So instead of a 3-year delay, my amendment would exempt renewals for current H-1B employees, which give current employees the chance to apply for early filing without creating a loophole for outsourcing firms. What I offered Senator Lee after months and months of deliberation and negotiation was a good faith effort to find common ground. There are so many lives at stake, so many families following this debate, because it literally will decide the fate of each of these individuals applying for the green cards and members of their family. It is heartbreaking to meet these families who are waiting for years for a green card and to realize that the limitations of our system today make it so difficult. Many of these are good, hardworking people in America doing the right thing. In my hometown of Springfield, Illinois, there are physicians whom I've met and talked to personally who've driven hundreds of miles to plead their case with me. This one physician brought his young daughter. I think she was about 12 years old. I don't forget her to this day. She traveled 200 miles to beg me to try to help. And that's why I came in with this amendment in an effort to protect her and to give her family a chance to be part of America's future. I will now request consent to pass my amendment. I ask unanimous consent that the Judiciary Committee be discharged from further consideration of H.R. 1044 and the Senate proceed to its immediate consideration. Further, that the Durbin substitute amendment at the desk be considered and agreed to, the bill as amended be considered read a third time and passed, and the motions to reconsider be considered made and laid upon the table with no intervening action or debate.
Is there objection?
Mr. President.
The senator from Utah.
Mr. President, reserving the right to object, I want to thank and appreciate the work done by my friend and distinguished colleague, the senior senator from Illinois. Senator Durbin and I have worked on many issues, and we've spent a lot of time working on this particular bill. In our most recent round of negotiations, he's made a number of suggestions that we've incorporated many of those. I wish we could incorporate all of them. For the reasons that I gave a couple of weeks ago when we went through this, there are some of them that I unfortunately can't agree to because they would result in our inability to proceed. On that basis, I object.
Objection is heard. Senator from Utah.
Mr. President, we're living in some really unprecedented times. The economic impact of this global pandemic on our nation, our people, and our communities has been nothing short of devastating. Within weeks of the start of this pandemic, we went from being one of the best economies that the world has ever seen to some of the deepest levels of unemployment we've ever seen. While the unemployment rate improves each month, countless Americans are still suffering from business closures, from layoffs, and from furloughs. Ultimately, the best economic stimulus we can offer in this hour of need is to foster opportunities for Americans to find meaningful work and to achieve economic independence. We have to ensure that our immigration system does not punitively disadvantage our own citizens from working in their chosen field, does not create unnecessary obstacles to achieving economic independence, and that it does not unnaturally depress wages. I echo President Trump's bold call to put America's interests first as we work toward economic recovery. During this economic crisis, the Tennessee Valley Authority, a federally owned entity, made the decision to furlough its American workers and replace them with contractors who rely on work-based immigrant labor. Many of these same outsourcing companies are able to conduct operations for far less money because they pay immigrant workers below market wages and require them to work in some circumstances under terrible conditions. It was never the intention of any employment-based visa program to crowd out American workers in this way, or to allow for the exploitation of legal immigrant workers. And I fully support President Trump in making that clear in his actions earlier this week. And let me be clear, this legislation, S-386, the Fairness for High-Skilled Immigrants Act, does not add a single green card or additional visa to the current numbers. No, it only lifts the per-country caps on applications for green cards for immigrants who are already here. So it doesn't add to the number. It just lifts this artificial, arbitrary per-country cap. If in times of high unemployment, we need to reform our work-based immigration programs to protect American workers, let's do it. If we need to end the optional practical training program to ease the burden on American graduates entering the economy, let's do it. If we need to reform the H-1B programs and make significant reductions in the number of work-based immigrants who come into this country, let's talk about that. I support these reforms, and that's why I worked with Senators Grassley and Durbin, among so many others in this body, to add significant reforms to the H-1B program, to the Fairness for High-Skilled Immigrants Act. This includes a reduction in the number of work-based visa holders that any one company may lawfully sponsor. This reform, included at Senator Durbin's request, is a good one, and it aims to protect not only American workers, but immigrants as well, by significantly curbing a system that allows for both the exploitation of visa holders and the depression of wages for all employees in a given sector. Its passage into law will increase the opportunity for Americans to compete for these positions. The bill also includes provisions strengthening the Department of Labor's ability to enforce and investigate claims that employers are providing less than fair wages and working conditions for immigrant workers, requiring employers to disclose more information regarding their H-1B hiring practices, and ensuring that employers may not use other visas to circumvent the H-1B caps. We must put Americans first. These provisions seek to do just that. Unless we're willing to completely end the work-based visa programs, we have an obligation to ensure that they're administered and allocated in accordance with the principles that we espouse as Americans. My goal in sponsoring this legislation many years ago, nearly a decade ago, in fact, was simply to bring some equity into this system. I've always been struck by the fact that the government is conditioned to benefit, in this case, a green card and a pathway to citizenship, given that this is an immigrant visa, a series of immigrant visa programs at issue, based solely on the applicant's country of origin. Now, there may have been some legitimate reason many decades ago, in fact, for this. I almost can't think of what those legitimate reasons might have been, but regardless, this has led to a system that largely discriminates against green card applicants from one country, and I mean literally one country, This is inconsistent with our founding principles. This is not how we try to do things as Americans, and it's not right. Today, if you're a work-based immigrant from India, entering into the EB-2 green card application process, you will wait almost 200 years before your application is even considered, solely because of where you were born. Almost 200 years on a waiting list. Mr. President, some people don't even live that long. Our country isn't much older than that, and that's the amount of time they would have to wait, based solely on the basis of the country in which they were born. If you're born anywhere else other than China, say in Ghana, in Sweden, Indonesia, basically any other country other than India, your application will be considered immediately. This sort of discrimination is simply inconsistent with the principles of a merit-based immigration system and with our founding principles and the principles that unite us as Americans. And so, Mr. President, I ask unanimous consent that the Judiciary Committee be discharged from further consideration and the Senate now proceed to H.R. 1044. Further, that the Lee Amendment at the desk be agreed to, that the bill as amended be considered read a third time and passed, and that the motion to reconsider be considered, made, and laid upon the table.
Mr. President, reserving the right to object.
The senator from Illinois.
Mr. President, I thank the senator from Utah for his response to my proposal. My staff received his amendment yesterday. We quickly reviewed the language, and I'd like to share my reactions. Senator Lee does not include my language to protect children of immigrant workers from aging out during the delay in early filing because of objections from his side of the aisle. I am disappointed. Senator Lee's amendment would modify my proposal, allowing for immediate implementation of the 50-50 rule. Excuse me. So the rule would go into effect after 180 days. Senator Lee would also provide that current H-1B employees may continue to change employers. The purpose of my 50-50 provision is to prevent outsourcing companies from continuing to exploit the H-1B visa program by hiring new H-1B employees. Senator Lee's language would not allow these companies to import new H-1B workers to exploit, so that is not objectionable to me. Senator Lee's amendment also accepts my proposal to delay by 1 year the bill's section changing the distribution of green cards to allow processing time for pending applications. To sum it up, the amendment currently being considered, for which unanimous consent has been asked, includes several key provisions I've advocated for that were not in Senator Lee's original bill, including early filing to protect immigrant workers and their families stuck in the backlog, an annual green card set aside for immigrant workers who are ineligible for early filing because they're overseas, a 1-year delay in Section 2 of the bill to protect immigrant workers with pending green card applications, and the 50-50 rule to protect American jobs and workers and to prevent the exploitation of immigrant workers that helped create the green card backlog. Therefore, I'm prepared to accept this amendment in the spirit of bipartisan compromise. I will not object to Senator Lee's request.
Mr. President.
Is there objection? The senator from Florida.
Mr. President, reserving the right to object. I clearly appreciate the hard work my colleagues have put in this measure. Florida is an immigration state, and we value our diversity. We also need to fix our immigration system so it makes sense. That starts with securing our borders. I've heard from many of my constituents about this bill because it impacts so many people in my state, including those who came to Florida from Latin America. We also have to help those who are escaping Communist China crackdown on freedoms in Taiwan and Hong Kong. So today I want to offer an amendment to make sure we are not creating an unfair system that favors certain nations that would disadvantage immigrants that do not happen to be from the nations that are the largest drivers of the employment-based visa backlog that we see today. I know my colleagues share my desire to preserve the diversity of our nation, and I look forward to them accepting my amendment today. Therefore, I ask that the Senator from Utah modify his request to include my amendment to the Lee Amendment at the desk. The amendment be considered and agreed to. The Lee Amendment as amended be agreed to. The bill as amended be considered read a third time and passed. And the motions to reconsider be considered made and laid upon the table.
Does the senator from Utah so modify his request?
Mr. President, reserving the right to object, Senator Scott's proposed amendment would, to be clear, create a carve-out for people based on the language that they speak. Now, to be very clear, unless their language skills are somehow part of the analysis, determining whether or not they qualify for an employment-based immigrant visa, I do not see that making a carve-out for particular languages would be consistent with our immigration goals or with principles of fairness or of equity. Amendments that, like this one, purport to carve out groups of people based on their nationality or their ethnicity or native languages are antithetical to the type of equitable change that we've been pursuing with this bill for years. And so when we look at this, it operates quite broadly. It's trying to create a carve-out for people who are native speakers of Spanish, Portuguese, Haitian Creole, Cantonese, Taiwanese, Hokkien, or Hakka, or who have attained a master's degree or higher in the aforementioned languages, or people who are spouses or children of people in the aforementioned lists. That's a lot of people who have been identified there. Interestingly enough, this doesn't include other languages, and I haven't heard any principled basis upon which we could differentiate between those two. So it seems to me that in fixing one problem, if we reinsert this amendment in there, giving preferential treatment to people who, by the way, are not speakers of Hindi or of Urdu or of other languages commonly spoken in India, I don't understand the principled distinction between these language speakers and others. But more fundamentally, Mr. President, this undermines and contravenes the fundamental purpose of this legislation, which is to say that regardless of what other factors you might take into account, when deciding how you're going to allocate employment-based green cards, the one thing that we shouldn't look to, and that no longer makes any sense to look to the extent it ever made sense to beginning to look to, which it probably didn't, is the country of origin. This makes no sense, and it's wrong. And I therefore cannot support the amendment offered by my colleague, Senator Scott, and object to its adoption.
Is there objection to the
Mr.
original
President?
request? Senator from Florida.
Reserving the right to object. Clearly, I'm disappointed. My colleague is unwilling to accept my amendment. My goal is to be fair to the many wonderful and skilled people that want to build a life in our great country. I've also spoken to the White House about the bill, and they agreed we need more time to review the proposal and understand its impact on our immigration system. I hope my colleagues want to continue to work together. I hope we can find a path forward to address the current visa backlog. Therefore, I respectfully object.
Mr. President?
Objection is heard. The senator from Utah.
Mr. President, I'd go back to the question I asked rhetorically a moment ago. What is it about speakers of these languages, mentioned in the amendment offered by my friend and distinguished colleague, the junior senator from Florida, that is, to native speakers or speakers who hold a degree in the languages of Spanish, Portuguese, Haitian Creole, Cantonese, Taiwanese, Hokkien, or Hakka? What is it about speakers of those languages that makes them more deserving of an allocation of an employment-based immigrant visa than speakers of Hindi, of Urdu, or of any of the languages spoken in India? As I mentioned a moment ago, you've got a real problem, a real inequity. Overwhelmingly, the per-country cap punishes would-be immigrants from India in a way that it doesn't affect any others, except maybe some from China. And by the way, he covers some of the language groups spoken in and around China, including Cantonese and including Taiwanese. So why not Mandarin? And if Mandarin, why not any of the languages spoken in India? This cuts right to the heart, Mr. President, of why it is that we need this reform and why it is we've got an Elvis Presley era, outdated, outmoded, unwise, and fundamentally inequitable immigration code, one that is at odds with the way our immigration system works. So if you imagine two otherwise identical applicants for a visa, they are exactly the same in all respects, in their academic degrees that they've earned, in their employment experience, in their background check, in their family status, their earning potential, their job commitment, professional certifications. They are identical in every single respect except for one. Immigrant A happens to hail from Sweden. Immigrant B happens to have been born in India. Immigrant A will be eligible to have an employment-based immigrant visa application considered immediately. Immigrant B, simply by virtue of having come from India, will in many circumstances have to be on a waiting list for 200 years. This is wrong. I really would like one day for someone, anyone, to explain to me why it makes any sense to leave this law on the books. They can't. They won't, because there is no good reason for doing so. And if they can't, and if they won't, why on earth would you want to weaken something and dilute something to create special privileges to one group of would-be employment-based green card holders, simply because they happen to come from yet another preferred country over the non-preferred, discriminated against country? This is wrong. We've got to get this thing passed. I'm so grateful to Dick Durbin and the work that he's done with me on this. I'm grateful to my colleagues on both sides of the aisle who have put together this bipartisan bill. I believe we're close. I believe we're very close. I intend and plan and fully commit in the coming days. I'm going to keep pushing this. This issue isn't going away. We're going to get this thing passed. Thank you, Mr. President.
President.
Senator from Illinois.
Mr. President, I'm disappointed after all of these months of negotiation, emotion, intensity, and the feelings that we share for the people who are caught in this backlog. It is a real disappointment that at the last moment, the senator from Florida exercised his right as a senator to object to our unanimous consent request, a request which I was prepared to accept. May I suggest this is an illustration of the bottom line that I raised in my statement. Stuck with 140,000 limit on the green cards for employment visas and country caps for that 140,000 limit, we will continue to run into the problem illustrated by the senator from Florida. There will be those who want to create an exception to the overall quota or the country caps. And there will be compelling personal and family reasons for them to ask for it. And time and again, they'll find that if they get a privilege, it will be at the expense of someone else, and there'll be an objection. The only rational answer is to raise the cap on the green card quotas. 140,000 employment-based visas a year might have made sense 30 or 40 years ago. It makes no sense today in the world that we live in. We are talking about people in the United States working, who are trying to make a life here of a more permanent nature. They love this country enough to want to bring their families here, to relocate and live. They're working here and contributing in the computer industry and healthcare and so many different areas. They're valuable and important to the future of America. I sincerely hope that we can resolve the issue that was brought up on the floor today. But equally important, if not more important, I hope that we will have the will on a bipartisan basis to tackle a comprehensive immigration reform. We did it 7 years ago. We passed it 7 years ago. It can be done with senators of good faith and goodwill who work together. But it means that you have to accept the premise that there may be one additional new immigrant coming to America. Some people cannot stomach that, and they object to any efforts to change immigration laws that might result in an additional immigrant. This son of an immigrant, who happens to be a United States Senator, believes that immigration defines this country. Our diversity defines this country. And bringing people here who are willing to sacrifice and risk everything to be part of America's future is part of the reason why we have prospered as a nation. I hope that senators at both sides of the aisle will have the good sense to come to that conclusion, and that at another time with another Congress and perhaps another president, we can have a meaningful and fair-minded conversation. In the meantime, I will work with Senator Lee to resolve the differences that we have, which are now down to only a handful. I believe we have made dramatic progress as evidenced today. We're disappointed by the result, but we are not giving up. I yield the floor.